Everyone, thanks for being here. Try to go ahead and get started. So I was planning to just introduce Alison quickly and get out of the way, but I've now been asked a few times how the law school is doing and what's going on. So I thought maybe I'll talk for just a minute or two about what's been going on at the law school and how it's going. The short answer is I think the law school is in a fantastic place and has been absolutely thriving over the last few years. I'm a law and economics person, a data person, so some numbers behind this. One of the things that I think this school has been just extremely successful at is placing our students into federal clerkships and clerkships with judges coming out of law school. We just got the most recent data a month or so ago. Was released by the ABA about all of the different schools' clerkship numbers. Over the last 5 years, about 25% of our class has gone straight to a federal clerkship. To put that perspective, Yale is second at 23%. I think Harvard's at something like 16, and then after that, you're very quickly into the single digits. And so we're not only first, we're I think pretty far ahead of the share of our students going into clerkships after graduating. This year, for instance, not just overall students going to clerkships, we had 7 students clerking at the Supreme Court. And then beyond that, students are going to firms, public interest jobs, a range of outcomes. I think our students have just the amazing outcomes and the best outcomes of any school. In fact, there's a website above the law that's the sort of legal gossip site that puts out its own law school rankings. And their rankings, their gimmick is that it's entirely based on outcomes. So they don't look at your incoming GPA or your incoming LSAT scores or your resources like this. They just look at how you place your students and where you go. And they just about a week ago released their latest law school rankings, and we're first in that ranking. So if you look at where students place, we do better than anyone. The incoming students are fantastic too. The class that just finished their 1L year, both on their LSATs, their undergraduate GPAs, et cetera, is not just the strongest class that we've ever had, but we think is the strongest law school class that any law school has ever had. We just had deposits this year come in on June 15th for the class that'll start in the fall, and we feel pretty strong about that too. So things are just in a great shape. And then on top of that, and you'll see a little bit of this in a minute, I think the faculty's in a really strong place. I was just explaining this a minute ago, but one thing that's worked really great for this law school is that in roughly 2008, most law schools stopped hiring new law professors because endowments took such a crash. So there's this big period where the top law schools took off hiring. But this school and this university continue to invest in hiring its faculty, which I think has been a big part of what has made this law school special throughout that period. And now I think we're really seeing the benefit where we have a really strong faculty in the prime of their careers at a time when many law schools, from failing to invest 15, 20 years ago, are not in that same position. So I think the faculty is in a really strong position. The students are great coming in. They're having great outcomes coming out. And then I think culturally, we've had a fantastic year. One measure of this, the Dean of Students and I had 0 emergency meetings of any kind. There were no incidents this year. No talk that went astray, students that had to be disciplined, no disciplinary cases of any kind. And in higher education, the number of talks that blow up or speakers or incidents or things that end up being against it happens all the time at our peer schools. We had 0. And so culturally, the school's in a strong place. The students are happy, thriving, etc. Now, what you're here for today, though, is not to hear me talk. It's to hear my colleague Alison Siegler talk. Alison Siegler is the Lillian Kraemer Professor of Public Interest Law, and she runs our Federal Criminal Justice Clinic, which she founded 18 years ago. 18 years ago was the first federal criminal justice clinic in the country of its kind. So they focus on federal criminal defense cases, important high-profile cases. And last year, Alison became our one and only clinical professor that has an endowed professorship, the Lillian Professor of Law. And she gave a presentation at the endowment ceremony on her work on the Freedom Denied Project, which is absolutely fantastic, and what she's going to be speaking about today. And I'm excited to hear it because I've heard that even since last fall, there's been more progress and more updates on what they've accomplished. And so I'm excited to welcome Alison to tell us more about her work. Thanks, everyone.
Smith was arrested, he was brought into federal court for his very first bail hearing, and this is called the initial appearance hearing. There was a federal magistrate judge sitting on the bench, and there was also a federal prosecutor there. And the prosecutor was asking the judge to lock James in jail, right, which is known as pretrial detention or pretrial jailing. Now, federal law required the judge to appoint a lawyer to represent James from the very beginning of that hearing. But in that case, that didn't happen. Instead, James was forced to stand up there and handle the hearing on his own. And he, of course, had no idea that he was entitled to a lawyer, and he had no idea how to defend himself. And he also had no idea that by answering the judge's questions, he was actually incriminating himself. So the judge turned to James and said, "What is the balance in your bank account?" And James honestly replied, "Currently it's probably zero. That was the reason why I accepted the job." And this was James admitting to the crime, okay? The crime that up until that moment, he was presumed innocent of. My student, Sam Bonafide, was watching this hearing, and he knew the law, and he was appalled to see the rule of law subverted before his eyes. And Sam called me up and he said, "You'll never believe what I just saw. Like, a man was standing in front of the court without a lawyer representing him. I watched him admit to the crime, and everyone acted like it was totally fine." So I want to thank Dean Chilton for that incredibly kind introduction. I also really want to thank Dean Chilton for the opportunity to present this lecture, and also for the unwavering support that he has provided to our clinical program here at the law school. Today, I'm going to tell you about a massive data-driven project that our federal criminal justice clinic spearheaded, in which we identified a pretrial jailing crisis and then transformed the system. So when I founded this clinic 18 years ago, as Dean Chilton said, it was the very first clinic of its kind in the country, the first clinic that enabled law students to stand up in federal court and represent clients in serious federal felony cases. We were also fairly unique among criminal clinics in a commitment we had to expanding beyond that individual representation and even beyond litigation. For decades, the bread and butter of law school clinics had been what I call traditional one client, one case litigation. And I trained in one of those clinics at Georgetown. I have enormous respect for the work they do. But what I wanted to do in creating this clinic was to explore new ways of enforcing the rule of law where it matters most, when liberty is at stake. And I really wanted our students to come away from their clinical experience believing in their own power to change the system. I wanted to empower new lawyers to know how much they could do with this law degree. And I call our clinic's approach transformative advocacy. We learn of a systemic crisis, and often we learn that by representing individual clients in individual cases. And then we gather data. We investigate the crisis, and then we pull every possible lever to fix it. Using this transformative advocacy approach, using an approach that moves beyond traditional one client, one case litigation, our clinic has shown time and time again that a small handful of people can actually bring about nationwide change and can help enforce the rule of law. I owe a great debt to Professor Erica Zunkel, who's there in the back. She, for her partnership, her dedication, she was our clinic's associate director. She helped build the clinic with me. Also to Professor Judith Miller, who couldn't be here today, but for running the clinic with us for over a decade. The other clinics at this law school are certainly also leaders in implementing this beyond litigation model that I'm discussing today. In fact, this broader approach to advocacy, this ability to craft solutions to systemic problems, that really sets Chicago's clinics apart from most of the other clinics in this whole country. One exemplar of our clinic's transformative advocacy work is what I call the Freedom Denied Project. So for years, my students and I and Professor Zunkel and Professor Miller, we walked into court representing our clients, right? And we were representing them at these initial appearance hearings, and we watched judges and prosecutors misapply and misunderstand the federal bail statute. We wanted to figure out what was happening, so we dug into the public data. And we learned that nationally, 75% of people charged in the federal system were being jailed pending trial. And as you see here, that's far higher than the 45% pretrial detention rate in state-level violent felonies. And you see here also that people in federal cases are not generally classified as violent. We also learned that the amount of time every person spends behind bars pre-trial had ballooned in the federal system from 2 months all the way up to a full year on average. Average 1 year while pre-trial. And to be clear, we are talking about people who have been arrested, they've been charged, but they are presumed innocent. We looked at the law and we realized, wait, this doesn't make any sense. Like when you look at what the Supreme Court has said about the federal bail statute, there's basically a presumption of release. They said in our society, liberty is the norm, and detention prior to trial is the carefully limited exception. And this, by the way, was written by that raving progressive Chief Justice Rehnquist, okay? just so you know. But the publicly available data also shows it doesn't make sense to lock up so many people for so long because 99% of people who are released pre-trial in the federal system appear for court, and 98% are not rearrested while they're out on release. And get this is my favorite image from our Freedom Denied report. It's not just that we're releasing the right people. Because when release rates increase, flight and crime do not. So those are the concerns that are driving pretrial detention. This concern that somebody who's on release is going to go out and either fail to come to court or do something dangerous, right? That's the worry. But those concerns are not in any way borne out by reality. And the public data showed us nothing about, what is happening on the ground. What is happening on the ground in federal court that might explain these sky-high pretrial detention rates? So Professor Kunkel had this brilliant idea, and she said, let's investigate this problem through court watching. And gather our own data and figure out what's going on. So this tool of court watching, it had been used to great advantage in state courts around the country, but nobody had ever thought to use it in federal court before. After a pilot study in Chicago, the students and I decided, you know what, let's pursue a national investigation. And this was the first national investigation of its kind. No criminal clinic had run a project like the one that we created here. And our approach was quintessentially use Chicago, right? We said, look, let's gather evidence about the problem, figure out what is going on, before we can have any idea of how we're going to go about fixing it. But then let's also fix it. So from 2020 to 2021, the students and I gathered quantitative data by watching court watching in 600 bail hearings in 4 federal courts over Zoom. My student Sam was a team leader of that project, and the Smith case was just one case that he and many other students watched during that time. They watched these cases, they took verbatim notes on what was happening, and then they recorded the data into these complex Qualtrics surveys that we had created for this purpose. And then from 2021 to 2022, the students and I gathered qualitative data. We went off and we interviewed 50 judges and lawyers from courts all across the country. This was truly an interdisciplinary project. We worked with people across the university. We also worked with law clinics we partnered with Harvard, BU, University of Maryland, so that those clinics and their students also helped us gather the data. And what we ultimately discovered was really shocking. We learned that federal judges regularly lock people in jail in violation of the federal bail statute. And that, of course, drives up jailing rates. The students and I then spent many months writing up our results in this nearly 300-page report that I think a lot of you have. We have more if you need one. And this became the pillar of our Transformative Advocacy project. I'm thrilled to say that we have had great success in bringing these courtroom practices back in line with the rule of law. So I'm going to focus on two of our central findings, and then I'm going to describe our multifaceted approach to fixing those problems and changing the system. Our first finding is this. Judges were routinely locking people in jail in violation of the statute at these initial appearance hearings. Okay, so the initial appearance, as I said, is the first hearing in every federal criminal case. It's governed by a legal standard that is contained in section 3142F of the statute. On its face, this is what F does. On its face, it limits the types of cases in which the judge is authorized to jail somebody at the initial appearance hearing. If the prosecutor can establish what I like to call an F factor, then the judge can jail the person. They can jail the person and they can hold something called a detention hearing, the next type of hearing that could come in this case. But if the prosecutor cannot establish an F factor during that very first bail appearance, the person has to be released immediately. No detention hearing can be held. They have to be released and they return home to their family as their case proceeds through the system. In our study, students were startled to learn that judges and prosecutors and even defense attorneys, no one really understood this law. And they were disregarding this statute. They were ignoring the F factors. In 81% of initial appearances that we watched, prosecutors failed to provide an F factor to justify their detention requests, even though this is the gatekeeper, right? F. They have to show you an F factor or the judge shouldn't be locking somebody in jail. But in 99% of hearings where the prosecutor asked the judge to jail someone for a reason that was not contained in the statute and not authorized by the statute, the judge just jailed the person anyway. As a result, in 12% of cases, people were detained unlawfully. And jailing people improperly obviously drives up pretrial detention rates because what you have to understand is that most people who are locked in jail at that first hearing, most of them remain in jail for the entire duration of their case. And as I told you, that's on average 1 year, okay? So this is the essence of our first finding. People were being locked in jail in violation of the statute at these initial appearance hearings. Now, the second finding, I went too fast. The second finding relates to, hold on, my friends. Here we are. The second finding relates to what Sam saw during court watching, which is we uncovered this nationwide deprivation of counsel crisis. We found that judges across the country were jailing people at initial appearance hearings without first appointing them a lawyer to represent them during that hearing, even though that's like a blatant violation of statutory law. 90% of the people, you need to understand this, 90% of the people charged in federal court with federal crimes do not have the money to hire their own lawyer, okay? So they are totally dependent on the judge to appoint them federal public defenders. During the interviewing phase of our study, the students and I were surprised to discover that 1/4 of federal courts in this country, in 1/4 of courts, judges regularly jailed people without lawyers. And we call these the problem districts. Now, in the 4 years since our report, we have gathered a lot more data, and we have learned of additional problem districts. In fact, over the past several decades, as many as 30 federal courts regularly deprive people of counsel during initial appearance hearings. You have to understand that is 1/3 of the 94 federal courts. 1/3, okay? And this was like a really dirty secret that our report blew wide open. These two legal violations were connected, the two we've talked about. If somebody's not represented by counsel during that initial appearance, right, like there's no one to prevent the unlawful jailings that we documented. Unsurprisingly, pretrial release rates were higher when people were represented by counsel. So in our study, 1/3 of represented individuals were released at their initial appearance hearing, but 0 of the unrepresented individuals were released. 100% of them were detained at their initial appearance, of course, because they didn't have a lawyer representing them. They were all locked in jail pending trial. So, we could have put our findings out into the world and just kind of stopped there, right? But for us, discovering and exposing these legal violations, that was really just the beginning. The next challenge was to develop transformative advocacy interventions that would realign courtroom practices with the law as written. So to increase public pressure, we convinced USA Today to take an exclusive on our report. And they wrote a very un-USA Today, length article. Really cool. You might want to check it out. Next, the students partnered with me to educate thousands of stakeholders nationwide about the correct legal standards, okay? Including federal judges, federal public defenders, federal pretrial services officers. So we were invited to present speeches at national judicial conferences, annual circuit conferences, and we mailed our report out to all the federal magistrate judges and all the chief federal district court judges in the country. Then the students and I set our sights on rectifying this right to counsel problem. So we brainstormed and we thought really hard, who can help us fix this issue? And ultimately, we convinced high-level policymakers in all three branches of government to join us in rectifying the crisis. So we did something very unusual, which is we decided to start with the executive branch, the Department of Justice, which is typically, our clinic's adversary. We do the defense work and they're doing the prosecution work. We laid the groundwork in 2021 when clinic student Kate Harris and I wrote an op-ed in the New York Times where we pushed DOJ to change their approach to pretrial detention and their policies. When the Deputy Attorney General later came to speak at the law school about a year later, clinic student Claire Downing presented her with our concern that people were being locked in jail without lawyers. And the DAG, as you can imagine, was quite surprised by this and actually hadn't been aware that this was happening. And what Claire said is, we want the Justice Department to issue a directive to federal prosecutors. And that is exactly what they did. The DOJ added a groundbreaking new directive to their justice manual that addressed a number of the problems we'd identified, but the one I want to focus on is this. They said, prosecutors must recognize that a defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding, including initial appearance. This is a huge victory, right? The Justice Manual is like the Bible for federal prosecutors. And it was also a great lesson for our students because it taught them, the rule of law can serve as common ground, even between traditional adversaries. And you never want to shut off any potential advocacy avenue. So you just want to advocate with everybody you can. And honestly, the reason we thought about the DOJ was, well, they're a unitary system. They make policy and it goes downward, whereas the judiciary was a little harder to figure out. But armed with that DOJ directive, students and I began advocating to the judicial branch. And what we did was we approached judges on the Judicial Conference of the United States, right, which is the policy-making body for the federal judiciary. It's helmed by Chief Justice Roberts. And two brilliant students wrote a letter to the Judicial Conference where they sort of laid out the problem, laid out the law, laid out our data. And miraculously, in 2024, the Judicial Conference issued an extraordinary directive to all 1,200 federal magistrate judges and district court judges in the entire country. And it says, courts that do not currently ensure that every defendant has active representation by counsel during the initial appearance must comply with the governing statute and rules. So this was a real turning point. And the students took away very valuable lessons from this advocacy process. So here's our student, Georgia Huang, when she was advocating to Senator Durbin when he came to visit our clinic a few years ago. And afterwards, she said, I've had a lot of practice learning to write for different audiences over the past year, whether it's a judge, a legislator, a defender, or the general public. I am certain this will make me a more effective litigator and advocate when I practice. Georgia clerked for the Federal Circuit. She's now clerking for the DC Circuit, and after that, she'll be at Sidley in Chicago. I am thrilled that the interventions we spearheaded have resulted in widespread and very concrete change, okay? So what you see here is most of the problem districts have now conformed their practices to the law. Of the 30 courts where the problem existed in the past, 25 have instituted reforms, and they are now appointing counsel to represent every single person during their initial appearance hearing. Over the past 3 years, the students and I worked together to gather additional data, a lot of additional data. We conducted over 125 new interviews with judges and lawyers from 63 federal courts. This Freedom Denied project that I'm telling you about, I think it really shows the power of advocating with both evidence and law. You know, like, I'll just tell you a story. When I gave a speech at the 10th Circuit Judicial Conference a few years back, a guy came up to me afterward, and he introduced himself, and he was the U.S. attorney for the District of New Mexico, so the chief federal prosecutor for that district. And he handed me a dog-eared copy of the Freedom Denied report, and he said, "Would you sign this for me?" And I was so floored and so excited, right? And then he went on to say, "I learned from your report that it's unlawful to hold initial appearance hearings without defense counsel. And after that, I pulled together all the key stakeholders in the District of New Mexico, and we fixed this problem." You know, and you can see here, New Mexico's green on this map, okay? Just an example of how, you know, you wouldn't expect that the prosecutors would want to fix the problem, but they do, because they also want to make sure that the system is working. Other problem districts have also changed their ways. So take the Southern District of Florida. This happened during an interview for a report, okay? A federal judge told my students that before the pandemic, around 30% of initial appearance hearings occurred without a lawyer representing the accused. But that changed after the judicial conference issued their directive. So last year, the chief judge released this administrative order, the chief judge for the whole Southern District of Florida, to ensure meaningful representation at every stage of criminal proceedings. It is ordered that the United States District Court for the Southern District of Florida formally adopts a policy to ensure that every criminal defendant has active representation by counsel before their initial appearance. In the Western District of Tennessee, historically, many people were not represented by counsel at federal initial appearance hearings. And once again, the Judicial Conference Directive changed everything. So after our clinic partnered with the federal defender out there, the chief judge issued this administrative order. The court hereby appoints the Federal Public Defender's Office to provide limited representation to each defendant prior to and during their initial appearance, to make sure everyone would have access to a lawyer and someone to argue for them at this hearing. Administrative orders like these, they really fix the problem in one fell swoop, and they also provide a best practice for other districts to follow. And I'm thrilled to tell you that we are now down to just 5 problem districts. The students and I are using additional transformative advocacy tools to, try to fix the problem in those final 5 courts, including legislative advocacy. So I want to tell you a bit about our legislative advocacy work. Back in 2019, I testified before Congress about federal bail reform, and then Professor Zunkel and I spent hundreds of hours working with our students to rewrite the federal bail statute. And we had Rubenstein scholar Alex Aparicio sitting here. She was really leading the charge on this. And amazingly, Jerry Nadler, then the chair of the House Judiciary Committee, introduced our rewrite as the Federal Bail Reform Act of 2020, even though it didn't end up moving forward. Then in 2023, Senator Durbin came and met with our entire clinic at the law school. And 4 students presented our findings from this report to the senator, and they told me later it was like a total highlight of their law school experience, of course. This past fall, Senator Ossoff issued a hard-hitting oversight letter about our study. This entire letter is focused on our study, and it ended with this call to action. Given the gravity of these findings, I urge the Judicial Conference to prioritize this issue as a matter of urgent concern and bring the offending district courts into compliance with federal law immediately. Okay, so it's all very exciting. Now, up until this point, I've been really talking to you about the non-litigation interventions that we use to rectify the deprivation of counsel crisis. But we complemented that approach with a mass litigation project to address the first finding I told you about, the problem of judges jailing people without statutory authorization, without that F factor, okay? So I want to tell you how we did this. We decided, the best way to handle this particular issue is litigation. And of course, we can't litigate all over the whole country. So our students wrote template motions to prevent people from being locked in jail without an F factor. And then we pushed these motions out to federal public defenders all across the country. We actually got them published in this Westlaw database. So anyone can use them. Anyone can find them. And before this, you have to understand, it was extraordinarily rare for federal criminal defense attorneys to write motions for pretrial release. They would just argue orally. And in fact, even if we think about oral argument, in all the cases in our study where people were improperly jailed without an F factor at their initial appearance hearing, not a single lawyer even made an oral argument against that practice, against what was happening. Not one, okay? But as of today, thousands of defense attorneys have downloaded and filed our motions, and it is making an enormous difference. So in response to those motions, in response to our report, judges around the country have been writing opinions. And of course, you can't write an opinion if you don't have a written argument in front of you, right? But with the written motion, judges have been able to write opinions. And those opinions realign courtroom practices with the rule of law. The judges are saying, hey, wait a second. This has not been working correctly. Let's write about this to make sure everyone understands how it's supposed to work. And in every single one of the cases on this map, the judge concluded that the statute did not authorize pretrial detention and sent the person home to their family. One federal district court quoted our report in an opinion. And this is a quote from our report, but it's in their written opinion. The prosecutor requests pretrial detention for reasons not authorized by the law, so they're laying out the problem. The defense attorney does not object, and the judge neither questions the prosecutor nor adheres to the statutory requirements, sometimes jailing people unlawfully. So they quote our report, and then the judge says, but such practices cannot amend the text of the act, which carefully limits the circumstances under which a detention hearing may take place. And again, drawing directly on our report, the judge then laid out each party's statutory responsibilities in a way that is so wonderful and clear. She said, under the act, the government must proffer information that demonstrates a case is eligible for a detention hearing under 3142F. Then courts must make a finding by preponderance of the evidence that a 3142F category is present. And finally, defense counsel must be vigilant in ensuring these requirements are followed. It is incredibly exciting, as you can imagine, for our students to read opinions like these that are based on template motions they wrote, And the opinions on this map spring directly from our work, and they create this wonderful dense web of case law, which is providing best practices for all the other courts around the country now. But it gets even better, okay? This is the part, Dean Chilton, you haven't even heard yet. This year, the bench book that serves as the Bible for federal judges was rewritten around our clinic's interpretation of the legal standards for pretrial detention. I was very fortunate. I had an opportunity to work closely with the author to align the key chapters of this book, the ones about bail, with the bail statute's requirements. Among many changes, the new bench book says this: if the motion for detention fails to allege at least one of the factors in subsection F1 or 2, the motion must be denied and the defendant must be released. Now, I have to tell you why this was so exciting to me. When we first started interpreting the statute like this, a judge who will remain nameless said to me, "This is revolutionary. This interpretation, it's revolutionary." And they did not mean it in a good way, okay? And other judges just flat out told me I was wrong. I got told I was wrong over and over and over again in the course of this project. And people got very angry at me, actually, over this project. But it is thrilling to see our statutory analysis going from heresy to conventional wisdom in just a few short years. In another major reform, judges incorporated our clinic's approach to the statute into this really important federal form. They added a whole new section. It's called eligibility for detention. It lists the 7 F factors, okay? The F factors. So now, this is the form judges have to fill out if they want to lock somebody in jail. With this form, a judge cannot lock someone in jail unless they document the particular F factor they're relying on. These changes not only preserve the rule of law, but they will help protect the pretrial liberty of the 80,000 people who are charged every year in federal court with a federal crime. So this Andy Warhol quote really epitomizes how I think about our clinic's work. They always say time changes things, but you actually have to change them yourself. And I know there are others in this room who feel the same way. I recently had an opportunity to look back on my job talk, you all, okay, where I pitched this clinic 18 years ago. It was the talk I gave to the faculty. And I was floored to see that I had said this: one thing we could do is challenge long-standing and accepted practices that don't square with the law. For example, there's a complete disconnect between the language of the bond statute and the way it's enforced in this district. So I guess this Freedom Denied project was kicking around in my mind a lot longer than I thought, long before we put it into action. But now, at this point, as we stand here today, more than 50 clinic students have participated in this project, and I just want to say Ryan Jane Lou is here. He just graduated recently, and he has been an absolutely essential thought partner to me over the past 2 years on much of this. So the students tell me, that the written and oral advocacy that they did in the clinic served them incredibly well. It served them well in practice, whether they're writing motions, taking depositions, arguing in court. They've also expressed a lot of gratitude for some of the other clinical opportunities they've had, right? Like ones that are really rare at other schools, like advocating directly to high up government officials, to judges, to legislators. Each class of students on this project inspired the next class. So there's this community of alums around the country that have a real ownership for all the work that I'm telling you about today. I am totally blown away by our alums' remarkable professional accomplishments after graduation. The students who worked on this project alone have clerked for federal judges all across the country, all across the political spectrum. They've also worked in many legal markets in every sector, from big law to government service to public interest law. And this is just a few examples. Looking beyond the Freedom Denied project, I'm immensely proud of our clinic alums who have gone on to work in over 30 state and federal public defender offices. I'm also thrilled to hear from so many alums who are at firms and corporations about the incredible pro bono work that they are doing. I want to tell you about a few of our extraordinary alums who worked on the Freedom Denied project specifically. So the same year that Kate Harris co-authored that Times op-ed with me, she was a team leader and court-watching site manager of this project. And she led the writing of a major section of the Freedom Denied report. She, at the time, was also the executive articles editor of the Law Review, and she won moot court. Kate is now clerking for the Supreme Court, for Justice Sotomayor, after clerking for Judge Hamilton in the Seventh Circuit and working at a litigation boutique in New York. This is Kate. She sent me this picture. She texted it to me on her first day at the court. Rubenstein scholar Ale Clark-Ansani was one of 2 students who ran the qualitative interviewing phase of this project. And that year, he too won moot court. Ali took his expertise from the clinic into the public interest world. And he's now litigating bail issues with an extraordinary organization known as the Civil Rights Corps in DC. Jaden Lesnick was a team leader and one of this report's lead authors. He won the Clinic Award that year, and yes, he also won moot court. He's now in the DOJ's Office of Legal Counsel after clerking on the Ninth Circuit and working at Cravath. Jaden and I recently co-authored an article about this right to counsel crisis. It's going to be published this year in the Wisconsin Law Review. We're really excited about this because it gives us an opportunity to highlight a problem that has never before been addressed in the legal scholarship. And sometimes this is hard because we want to do the work and make the change, but then we also have to write about it and make sure others know what's happening. And so Jaden and I am so excited are putting this out in the world. So to conclude, the great scientist Edward O. Wilson once wrote, "Change will come slowly across generations because old beliefs die hard, even when demonstrably false." And yet in just 6 years, our clinic has made real progress towards banishing false beliefs about pretrial liberty and ushering in a new paradigm that more closely adheres to the rule of law. I want to share an email I received from a federal public defender in the District of Wyoming who authorized me to share this with you. And I think this really exemplifies the concrete change that our work has brought about. And I just want to say that before this project, the District of Wyoming had one of the highest pretrial detention rates in the entire country. So he wrote, "Hi, Alison. I wanted to send a quick note to say thank you. Between your trainings and the materials you've made available, we've seen a complete sea change in how cases are handled in the District of Wyoming. Instead of the old standard, where every case went to a detention hearing and the defense had to justify release, we are now filing responses in opposition to the government's motion for a detention hearing up front. As a result, our magistrates are routinely denying the government's requests for detention hearings entirely. This has led to immediate release for our clients. Thank you again for your leadership on this issue." So, I really hope that our Freedom Denied project showcases how much power there is. Power in moving beyond litigation, engaging in transformative advocacy, and mobilizing every branch of government to rectify systemic problems. As our students head off to become lawyers, I try to empower them. I try to empower them by saying, look, the law is a powerful tool for change. Each and every one of you can use the law to have a meaningful impact on this world. You have the courage to take action. You have the creativity to identify the levers to pull, and you have the tenacity to surmount any obstacles that may meet you along the way. I also tell our students this. I say continue questioning the received wisdom as you go through your careers. Never accept this answer, that's just how we do things around here. As this project shows, we can convince powerful people to recognize a problem and join us in fixing it. With the rule of law as our touchstone, we can right wrongs and transform systems. So thank you.